Right there. That is a freaking problem where I come from. When a guy's billed almost $700,000 and his contract had a cap and he's your goddamn boyfriend? Like, if this was you or me in a courtroom, I guarantee you we would be absolutely destroyed by a judge if we didn't have power to punish him later. You've tainted the jury pool, you've tainted yourself, you've tainted the district attorney's office, and you did it in a house of God. Shame on you. Good leadership means having the courage to sometimes piss people off. I love the smell of the odor of mendacity in the morning. Ladies and gentlemen, I'm back. Thanks to all of your requests. I'm sorry that I've been delayed. However, unlike many other legal commentators that you might follow on YouTube, I actually am quite a busy trial lawyer with an army, not an army, but a small special forces unit of lawyers who run trials that matter. And we take it very seriously. And we're currently in a very disturbing case where they're trying to make a 76-year-old lady into a criminal for making a pedal misapplication that resulted in tragic circumstances. And the government is doing all they can to try and put this lady away. And we're doing our best to protect her because she's a wonderful human being, and I'm not going to allow them to do that. But when you get into a jury trial, it's hard to do content. And everybody has been yelling at me to get something out on Judge McAfee's decision, and I'm going to do that today. What you're going to hear today is I don't think what you've heard from other commentators on this case of Fani Willis and the motion to get her off the record for a conflict and for forensic impropriety. A lot of the commentators have said that Judge McAfee's decision makes absolutely no sense. He essentially split the baby. He said one of the two prosecutors, Wade or Fani, have to come off. I don't think anybody was happy with it. But what I believe I'll tell you at the end is that this decision makes absolutely perfect sense in the circumstances. I don't agree with it, but it makes perfect sense, and I'm going to tell you why. First, I want to get back to my intro. This case will go down with a phrase, and I don't know where the judge got it from, but when he said, notwithstanding me not doing the thing that I know that I should be doing, I'm paraphrasing, he said, notwithstanding that, this case has the odor of mendacity. Now, mendacity is a 5-letter word like marmalade. Generally, I try to say complex things with simple words as opposed to the reverse, but especially in law, they use big words to say things that could be said simply. And in my law firm, I've banished under the punishment of torture anybody who says aforementioned, such as, same as, any of these nonsense phrases that are designed to make you look expensive when you can't really form a thought of your own. Mendacity essentially means lying. So you've got a judge saying, notwithstanding everything, it's got the odor of lying. And generally, you know, to use that word is to invite poetic memes, and I think they're going all across the internet. I would say this case has the stench of fucking corruption. And that's his softball way, his Mr. Rogers way of saying the stench of corruption by saying the odor of mendacity, and then he can click glasses at the Georgia Country Club. But, you know, he didn't step up on this case. I'll explain why. I looked up, you know, the first thing I thought of it when I read this decision, 21 pages. It could have been a lot longer, I thought, but, you know, for having a 2-week adjournment. But I got the sense he wanted to kind of get this over with and move. But I would say that the judge balked, B-A-L-K-E-D, phrase that we know from baseball. I'm sure we'll throw an image out there of a pitcher who starts the motions and doesn't finish it and breaks the rules, and the hitter gets to go to base. And it kind of looks like this judge started a motion and he was going to finish something, and then in the end, he just didn't finish it. He balked, right? It also means in the Cambridge Dictionary to be unwilling to do something. And this judge was unwilling to do the right thing, the thing that he knew he had to do. But I'll explain to you why I think it makes perfect sense. It's because of the situation that he existed in Fulton County. Now, what I know before we start this is that Fani Willis was lying and Nathan Wade was lying. I don't think there's anybody who's watched that testimony who doubts that they were lying. We know that the judge knows that they're lying. We also know he's facing an election. We also know he waited before he gave his decision to see if somebody would come and compete against him. That was a very tactical move, because if nobody was going to be running against him, I bet you this decision would have been different. And other people, political operatives, knew that. And so they deliberately ran a candidate on short notice against this judge for re-election who was more liberal as a way to influence his decision. This is the complexities that you deal with in the American legal system. It's not just about justice, even though everybody wants to think it is. It's about survival, careerism, and it happens at the judge level, it happens at the district attorney level, it happens everywhere. He also gave a press interview before he gave his decision. And I'm not going to get too much into that, but it's very unusual for a judge to hop on the news and talk about a case he hasn't ruled on yet. But again, it makes sense. Somebody had just announced they were going to run against him. So he goes on the press and he essentially speaks to the people that are going to vote for him, saying, I'm going to do the right thing. This is very difficult. He primes the audience about what he's going to do because he knows he's in a bit of a catch-22 situation. He knows what he should do, but he knows that Fulton County is also a huge majority Black population who supports Fani Willis. She is a local hero. I can understand that if you don't know her, but a lot of the kind of common folk want a hero who's standing up to somebody that they think is evil, is Trump, and so they want to support their team. And they see Fani as their team. And so they kind of filter out the bad stuff and are on Team Fani. I can understand that. That happens all the time. That's why people still support the Jets. You know, like it's people are loyal to who they describe as a team. I'd like people to start moving their loyalty towards good people rather than just people who look like me or who come from my town or who worship the way I do. I'd rather my tribe be good people who care and who are kind and who are strong. But that aside, we can understand why the judge is doing this, right? Because he's going to not get elected. He would have to go back to practicing in Fulton County, where there'll be a DA who's the most powerful person in a county. You have to understand, in these counties, the district attorney decides who to charge. And when somebody gets up there and brags about their conviction rate, you have to understand that conviction rate is a construction of case selection. District attorneys, and I've done some time in a variety of different offices across the states, because they're elected and they're elected on conviction rates, they don't always care about right and wrong. They will often pass on a case that should be prosecuted because there's a 50-50 chance they'll lose. That's the problem with electing them, right? But they'll also prosecute cases that might not be in the best interest of the public because it's a guaranteed win. They get another W on the board. That's what's so disturbing about it. So when somebody says, I've got a high conviction rate, it's because they select the cases they prosecute. But if they can select the cases they prosecute, they can also work with investigating officers who owe them favors to investigate rivals, investigate people they don't like, build a case. So if you're Judge McAfee and you don't get reelected and all of a sudden you're not sitting up there on the bench anymore and now you're a lawyer, in that area, there is a real sword of Damocles hanging above you from Fani Willis. You know, you disbar her, but if she gets back elected or if you remove her from the case, but she remains as a district attorney and you lose your judgeship, you have the most powerful person probably in the whole county with police forces that she could kind of marshal to investigate you. Nobody wants to live like that. So this is some real stuff here. It's not just sitting on our couches or in our lawn chairs saying, hey, he should do it. Like he's facing some real consequences down there. He's got his share of corruption. So imagine what he's trying to deal with. He's kind of in an impossible position, but it looks like what he did is he split the baby. On its service, I think it was Solomon who said that, we'll split the baby. So what he did is he didn't kick Fani Willis off the case, but he said there were some problems. And then he said that either her or Nathan Wade have to come off the case. So it was kind of a non-courageous move to go down the middle, but I'll explain to you why it makes perfect sense. And I think there's a lot more nuance to Mr. Rogers, our friendly Fulton County judge, than we give credit for. And I think he actually did the Trump side a bit of a favor. I actually think he did as much as he could be expected to do to help the Trump and other lawyers in this case get the right result that I think was worthy. You know, as an aside, I'm just looking at, I'm reminded of what my daughter sent me this. She goes to kind of a liberal university, and she's a very critical thinker who pushes back against professors. And she had tried to bring up this class in a criminal undergraduate course, and her professor essentially lambasted her for doubting a black female prosecutor just on its face without even knowing. And so it kind of embarrassed her in the class for raising the issues, because she was asking, what do you think about this conflict? My dad's been talking about it. And then after the professor kind of embarrassed her, a bunch of friends came over to her and said that was ridiculous. And so they all went and watched my video on Terrence Bradley, and they loved it. A bunch of the comments came in, and the sweet girl sent this to me. She made this little picture that I'll put up on there, but I'll just show you. It's we'll put a proper one up on the screen. And so she drew Terrence Bradley, and she wrote, "I don't remember why I didn't say I don't remember." And all her friends thought it was hilarious, and they asked if I could get this made into a T-shirt. So I'm going to get this made into a T-shirt, send it to the kids at the university who watched it, and maybe make it available if people want to do it. But I just thought it was quite sweet that she kind of stood up for me, and then got hammered by a liberal law professor, and then decided to make a little image. Maybe I'll pay for 30 of these, and I'll have all the students wear them into that law professor's class and see what goes down. So I thought it was hilarious. So there was two grounds asking for the removal of Fani Willis. One was on conflict, so the appearance of conflict or an actual conflict. I'm not going to go into all of the law, but how I would frame this: prosecutors, district attorneys have, as I said, they're very powerful. They have kind of the power over life and death, freedom versus living in a cage. So the courts and the justice system have said you have a very high standard of behavior, right? You cannot appear, and this is where you hear multiple times this kind of appearance of not being in a conflict. Like you have to, and I've worked in a prosecutor's office where your standards are so much higher than defense counsel or other lawyers, because you have to protect the institution so that the public has confidence that the system is free from bias. And the reason why I think the judge struggled a little bit is there's very few cases like this case, this fact scenario, because 99 times out of 100, if you raise a conflict, even if it's not huge, the boss, which might be the district attorney, let's say there's somebody raises a conflict with one of their prosecuting attorneys, the boss will say, okay, we'll just switch attorneys because we don't want to have the appearance of conflict. We want the public to think this is fair. And that happens almost instantaneously. I've seen it where prosecutors have been taken out where there's no chance there's a conflict, but the boss cares about the institution and makes sure that the institutional reputation is protected. Now, the problem becomes, what if it's the boss, the district attorney? And in this case, Fani Willis was the boss. And there was the appearance of conflict. The judge says it. We'll go through his decision. So when the boss, the district attorney, won't take themselves off the case for the appearance of conflict, where do you go from there? I believe that Fani Willis, an elected official, wouldn't remove herself from this case, which she should have done if she was being an honorable district attorney. And if it was somebody else, she would have told them to get off, because this is a political platform for her to maybe one day run for governor, for some other windfall. Because if this wasn't Trump, if this was any other scenario, you would remove yourself. But this is a battle. I think she's being funded and powered by political forces who want to bring Trump down, regardless of your politics. Like, I think that's objectively true. And so she dug in, because like if somebody said, hey, there's a conflict, and I know that I've gone on some cruises with one of my people, I'd be like, okay, let's get away from this so I don't have to expose it. But, you know, as the judge said on page 2 of his decision here, after 2.5 days of testimony during where the defendants were provided an opportunity to subpoena and introduce whatever relevant material evidence they could muster, the court finds the defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest. And to put an actual in front of it is annoying to me, because a conflict is a conflict. You don't have to say actual. If there was a conflict, there was a conflict. Through her personal relationship and reoccurring travels with her lead prosecutor, right, who she hired and approved the bills on. And the judge goes on to say, the other alleged grounds for disqualification, including forensic misconduct, are also identified. But very early in his decision, this is where we can kind of read into the decision, and I haven't seen this analysis out there really. He goes, however, the established record now highlights a significant appearance of impropriety that infects the current structure of the prosecution team, and the appearance must be removed through the state's selection of one of the two options. So either Wade or Willis has to go. And I'll get into this in a little bit more detail for those of you who like the law, but for the judge to say the established record now highlights the significant appearance of impropriety that affects the current structure, how can you say there's no actual conflict when the record reflects the appearance of a significant appearance of impropriety? This is on page 2. If there's a significant appearance of impropriety, that's the conflict. And they should, and then this is what burns my ass as a former military officer. You don't let the boss who's using the spotlight for their own personal interest decide if it's going to be Wade or her. Like, we all grew up in places where the leader takes accountability. In the military, it was called falling on your sword. The leader takes responsibility. If there's a significant appearance of impropriety, then the person who is the senior person on the job bites the bullet, falls on their sword. But the judge, and you're going to see it, he won't take on Fani Willis. And I think we can understand why. But that statement right there on page 2, significant appearance of impropriety, that's the indictment right there. That's gonna infect every part of this going forward. But he didn't finish the swing. He didn't finish the pitch. He balked. It's embarrassing at one level, but understandable at another. Although this gets a lot of people upset they didn't kick Fani Willis off, what I think he did was lay the kind of interlocking stone or the pavement that the Court of Appeal can drive down to kick her off. And you want to understand why that's important. We'll move past from page 2, where the judge kind of, what I'm going to call kiss slaps Fani Willis. Says, I'm not going to do what you were scared I was going to do, but I'm going to say that there was a problem here. And we go to page 6. This is where the judge is talking about the decision to hire Nathan Wade. And he kind of says, oh, well, the hourly rate was a little low. And this is where you bury stuff in the details and make it look like you care. He goes, the district attorney considered 2 other options. The contract allowed $250 hourly rate, which was relatively low. And then this sentence I haven't seen anybody talk about. A relatively low amount by Metro Atlanta standards for attorney with Wade's years of service, and contained a ceiling on the maximum number of hours permitted. So there was a ceiling. Under the terms of the first contract, Wade was not to perform more than 60 hours of work per month without written permission. No evidence introduced indicates that Wade ever received permission to exceed these monthly hourly caps, and his contract was renewed 2 additional times. Now, what does our smart listener think about what this means? We know he billed almost $700,000 over 2 years. We can do the math that 60 hours at $250 an hour a month is a fraction of that amount. But the judge puts in there, Wade was not to perform more without written permission. No evidence introduced indicates that Wade ever received permission. So one of 2 things is true. Wade was ripping off the district attorney's office without Fani Willis knowing. Or Fani Willis said, just bill whatever you like. I'm not going to enforce this contract. I'm not going to give you written permission to do it. There's going to be no paper trail. Right there. That is a freaking problem where I come from. When a guy's billed almost $700,000 and his contract had a cap and he's your goddamn boyfriend, and he doesn't think that's a conflict, but he does. But what he did right here, ladies and gentlemen, what he did by putting that right there on page 6 is he essentially tied a bow around it for the Court of Appeal. And he's like, hey, guys and girls, take a look at this. Because that, I'm telling you, is going to be an issue when the appeal, and we're going to talk about the appeal. Judge McAfee allowed this matter to go to appeal before it goes to court. I want to talk about it later, but some time has passed. So they made an application for leave to appeal. And Judge McAfee said, yeah, this is so important. I believe, and I'm going to authorize this to go to appeal, and I'm going to say it needs to be heard before the trial continues. So you can kind of see where I'm going, where it makes perfect sense. He splits the baby, which preserves his life, right? But lays the groundwork in the appeal to hand it up the chain so they can do the work where they're not vulnerable to Fani Willis attacks like he is in his neighborhood. That paragraph to me is amazing. I haven't heard anybody talk about it. I could be wrong. Put it in the comments if I'm missing something there, but it seems huge. He goes on later on this page to kind of describe all of these expenses. He paid for plane tickets. He paid for cruises. He paid for this. They went to Napa. They went to Tennessee, Alabama, South Carolina, other parts. They also admitted to dining out on multiple occasions and taking turns covering the bill. With seemingly full access to Wade's primary credit card statements, the defendants did not produce evidence of any further documental expenses or gifts. The total aggregate was $12,000 to $15,000. So he lays out all of the stuff that Wade paid for under a contract that wasn't being enforced for its caps. And then he goes on page 7 to say that the district attorney testified that the expenditures weren't meant as gifts. Well, the law doesn't allow the receiver of a gift to decide if it was meant to be a gift or not. There's an objective standard to look at this. And if you remember my Fani Willis video where she says, and she looks at the judge, and because Ashley Murthan goes, do you have any proof of this? And she goes, my testimony is proof that this happened. The evidence of one person can be held as proof. And I called BS on that. But I think this is kind of where the judge played a bit of a fast one on everybody here. District attorney testified that she reimbursed Wade in cash for the Aruba trip and that she gave him money for both cruises. She further claimed that she reimbursed him for the Belize trip and paid for Napa Valley. She said she also paid for meals. And this is where the judge, I think, is picking fly excrement out of pepper in the way that he's trying to make minor issues. But he goes on to say, such a reimbursement practice may be unusual, and the lack of any documentary corroboration understandably concerning. Yet the testimony of the district attorney withstood direct contradiction and was not so incredible as to be inherently unbelievable. Now, my friends, when I was talking about cross-examining Fani Willis, there's a lot of Sato supporters out there, but I didn't think Sato did that great of a job on Fani Willis. I actually thought, I spoke about Ashley Merchant and how she was the first to go, and she did as good a job as possible, all things considered, with Fani running out there and her not being prepared. So she just had to do it by the seat of her pants. But Sato, the one everybody thinks is amazing, and Trump has a history of hiring bad lawyers. If you love him to death, you have to acknowledge he hires bad lawyers. That recent case, the defamation case, horrific lawyering. I think because in many cases, he hires people who soothe his ego rather than people who tell him, hey, dude, this is not the right thing to do. But all that aside, Sato had time to prepare. Fani Willis hops onto the stand, agitated, all over the place. It was a cross-examiner's dream to destroy her. Ashley Merchant did her best. No criticism in hindsight of her. Sato dropped the ball on that cross-examination, but not wholly on his part. But the judge says that he accepts Fani's explanation that she paid in cash because she survived cross-examination. And that's where on cross-examination, you have to be a Pitbull. It's not one thing just to call yourself Pitbull Sato. You actually have to be a Pitbull. And you have to break it. You have to make it so painfully obvious that the person is lying that, as the judge says on page 7, not so incredible as to be inherently unbelievable. It's inherently unbelievable that a district attorney who's not allowed to receive cash for anything, who can't be seen to be getting bribed, it's inherently unbelievable that she would have all of these cash stores everywhere and no receipts for them anywhere if she was not a corrupt district attorney. And this is also, though, where the district attorney's office, through the objections, threw off the case. And I think most importantly, this is where the judge turned some dials on the case, because he stopped when he goes, go back to this, where he goes, I think your point has been made, move on. Well, what if my point was to say that this is inherently unbelievable and you made me move on because of objections before I could dig deeper and show how much of a liar Fani Willis was, how unbelievable it was. This is the part of the case that really pisses me off. I actually wrote bullshit when I first was reviewing this and put this on my notes. This is the DA. This is Judge McAfee, knowing he's going to be in the same neighborhood as Fani Willis, saying, because she survived you guys attacking her, I am not going to find that I don't believe her about the cash, right? That gives him a free pass, a get out of jail free card, let's say, because that saved her butt, his interpretation of the cross-examination. However, after that, this is where we've got kind of the kiss slap, right? And, in my sometimes I talk about doing a slap kiss when I'm talking to people, right? I'll come in and I'll like slap them and say, this is bullshit. You got to sort this out. It's garbage. You kind of shock them and then you go, but you're doing a really good job over here. And that's like a little kiss. And you can get people to respond sometimes if you do that well. But this is kind of the reverse. This is the kiss slap. This is where Judge McAfee says, hey, you survived. I don't completely not believe you, but what I'm going to put in my writing after is that this finding on page 9 is by no means an indication that the court condones the tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing. Now, when a judge says tremendous lapse in judgment and unprofessional behavior in court, wouldn't you think that her unprofessional behavior would have allowed greater latitude in the cross-examination? Like what I'd be saying is I was trying to cross-examine her. She was being obstructive and unprofessional, and you told me to move on. You didn't allow me to take her on, or the lawyers weren't able to take her on because she was being so unprofessional. So he can make a determination saying, because she was being so unprofessional, refused to answer questions, was being evasive, was giving testimony, was being argumentative, I find this as further evidence that she must be lying. Because somebody who wasn't lying about cash would be polite, would do their best to provide receipts, would do it. Like if this was you or me in a courtroom, I guarantee you on my eyes that we would be absolutely destroyed by a judge if we didn't have power to punish him later. Absolutely. If any other witness acts like this in a courtroom, the judge destroys them, doesn't give them a hall pass. And that's what's unfortunate about having elected judges and district attorneys. It's called, from legal terms, demeanor evidence. So judges and juries are encouraged, and I don't think it's actually always that viable. And just as an aside, they did a test where they took, I'll see if I can find the citation, a few hundred judges, and they watched the testimony of a witness, and they were asked to decide if they thought it was lying or not. It was 50-50. No better than odds, the judge's ability to detect a lie. However, judges sit up in court, listen to you, and make a determination if you're lying based on your demeanor. And sometimes this is where prejudice and bias can come in, because if you're not familiar with a culture and they're talking a way you're not used to, you might assume they're lying when really they just might be shy about sharing stuff. This is an interesting part of court. I don't want to go too far down. But why it's relevant here is demeanor evidence. The judge finds her demeanor to be evasive, unprofessional, and argumentative, but doesn't treat her like he would another witness. And this pisses me off. Just to finish up that analogy, the only people who can do better than 50-50 are generally seasoned detectives and some border security people, and people who study human behaviors like myself and some of my colleagues out there who really get into studying deviations from baseline that would show you that somebody is uncomfortable. There's no one thing that you can say, oh, if they do this, they're lying. But, one thing I've done in trials, you may try it. It doesn't always work. You can even try it with your spouse if you can get away with it. You ask them 4 questions that, this is a bit of a segue from the case, but I like to share some things. Be close enough so you can see their eyes, and ask somebody 4 questions that strain their memory. So if it's Friday, you say, hey, can you remember what you had for lunch on Tuesday? Watch their eyes. They're going to go up and look to one side or the other, depending on their wiring. It's probably going to be to the left. I might be getting it wrong today because I'm exhausted from the jury trial. But every time they access memory, their eyes are going to go one direction, because one side of the brain, one hemisphere, deals with memory, and the other hemisphere deals with creativity and producing images and forecasting. And so then you ask him, describe your ideal beach house. Describe it in big detail. You'll see that their eyes go to the other side. And if you can watch somebody and ask them a bunch of questions, I can establish a baseline that when I'm asking them things about memory, they look up to the left. When I'm asking them things about imagination or creativity, their eyes go up to the right. So if I'm close enough to a witness, I can be asking them questions about memory, but when I see their eyes go in the opposite direction, I know they're creating details. That's one way that you can tell if somebody's lying. That's demeanor evidence, no judges. Very few people are trained on that. Sorry for the segue, but I thought it's quite interesting. And see if that works at your kitchen table when you're talking to your significant other or even your kids. Like if you want to see if your kids are making up what they did the night before, ask them memory questions and then see if their eyes go in the same direction when you're asking them where they were last night. This tip brought to you for free from Philip Miller, the Rogue Lawyer. The reason why I just highlighted page 11 is the judge essentially, after making some of his findings, lays out how the Georgia courts of appeal have found conflicts. And I'm not going to read this paragraph to you because it's lawyer talk. It's kind of boring. But essentially what he's done is he's kind of made an argument for the appellate courts to interpret what he wrote in the previous pages and say, hey, but this is what Georgia really cares about. I just don't have enough here. And so he's giving them a path to overturn his decision so they can own the responsibility of taking down Fani Willis. I wrote it down as softball to the Georgia appellate courts. You can tell a good leader in that they will resign to protect the institution, right? Like if Fani Willis thinks she's the only prosecutor who could do this case because she has these special skill sets, she's kind of kidding herself. If she really cared about the county, if she really cared about the district attorney's office, and she really cared about justice, this perception of conflict, she would have just said, okay, I'll step aside, bring somebody else in. I don't want my personal dealings to get in the way with the citizens finding out what really happened, but she didn't do it. That's a sign of a very bad leader and a politically motivated leader. She could easily fall on her sword. And this is where the judge talks about on page 15. I don't know how he writes, and I think this is why like Alan Dershowitz and a few of the other commentators said that the decision doesn't make any sense because legally they're absolutely right. It doesn't make sense. You can't use these paragraphs but make findings like this in other paragraphs. But he writes, with these principles in mind, this court finds that the record made at the evidentiary hearing established that the district attorney's prosecution is encumbered by an appearance of impropriety. So the office of the district attorney is encumbered, means it's carrying the appearance of impropriety. And it's not created by mere statute alone, but comes from specific conduct. And the judge goes on to say, even if a romantic relationship began after Wade was hired, the district attorney chose to continue supervising and paying Wade, an independent contractor, while maintaining such a relationship. She further allowed the regular and loose exchange of money between them without any exact or verifiable measure of reconciliation. This lack of confirmed financial split creates the possibility and appearances that the district attorney benefited, albeit non-materially, from a contract whose award lay solely within her purview and policing. Now, read in its simplest terms, this is the indictment that gets Fani Willis kicked off the case. This is not, you're not a greeter at Walmart who gets a second pass for kind of letting your buddies in, or somebody who lets somebody skip the line. Like, you're the district attorney. You had a relationship with somebody whose contracts you weren't supervising, who was milking the system, who you were traveling with and you didn't carry receipts with. And he's essentially saying to the Court of Appeal, this is crazy, but I can't do anything. Please do the hard work for me. He lays out in as good an argument as any of the defendant's lawyers could do why there's a conflict. So, but he's using this paragraph to justify why one of them have to go. And I think any adult, any teacher, any boss, entrepreneur, military leader, police sergeant, anybody's would know that if this is the case, the top person has to go. You don't blame the contractor who took the job, who was allowed to bill. The boss was getting money and can't prove she paid it back. And and to say there's no financial conflict, we're going to get to this part because this burns my buttocks. Because he says it's not clear that she received financial benefit because she's not destitute. The judge essentially says, because Fani Willis makes $200,000 a year, it's not clear that these trips, cruises, hotels, and meals gave her financial benefit. This is where it should really upset people who care about institutions, because even if it's $1, there cannot be any indication. But to say that because she has a job doesn't mean that she benefited from cruises. You know, there's no evidence that she was going on 5 cruises a year before. You know, and nobody could get information because she prevented it for her to say how many she had gone on before. But if you're encumbered by debt and spending, you know, I've seen many people who are broke on $250,000 a year because they've got debts everywhere and a lot of obligations. So that's very bad reasoning that there's no conflict. He finds she got some cash, but it's not clear it's a conflict because she has a job, right? That's not the standard district attorneys and prosecutors are held to. It's crazy. Page 16 is where the microscript, beautiful Odor of Mendacity comes out. He's talking previously about when did the relationship start, and this is where he gets all muddy, but he goes, however, an odor of mendacity remains, which is, I put WTF there. But the court is under no obligation to ferret out every instant of potential dishonesty. This is garbage because Fani Willis is the boss. She doesn't have a boss. You're the boss, Judge. You're the one who ferrets out lying and truth-telling. And if you say there's an odor of mendacity because of the relationship, but you don't find an actual conflict, you're actually not a very brave soul. And my comments on this page are maybe not the most politically correct, but they reflected what I was thinking at the time for sure. So we go on to so in the end, he says, despite the odor of mendacity, I'm not going to order Fani Willis off, but one of you has to go. We all know that will be Nathan Wade. Alan Dershowitz called that accurately. I see all these other commentators. Everybody is just busy trying to say, hey, I predicted this. Like I'm not in the prediction game because there's a lot of politics there, but I think it's clear that there was a conflict. And I think Fani Willis will eventually be kicked off the case by the Georgia courts, the appeal courts. And the judge has given them the handbook for that. But lastly, he gets into the forensic misconduct. This means that, so prosecutors have to have the appearance of being ministers of justice. It is not just win at all costs. It's not just, we are in an adversarial system, but the people who are in charge of prosecuting cases have to have that air of institutional trustworthiness. So they can't use their microphone because they're the government. They can't use their microphone to pollute or tamper with a jury pool before the case. Now, Fani Willis is in the paper all the time. She's a hero to many of the people of Fulton County as the first female district attorney. She has a microphone. And anybody who earned their way there and really valued it would care more about protecting the institution and not about their political goals. Because when you're in a county that is vast majority Black and vast majority Democrat, and a lot of people hate Trump, although I think that's changing in some minority groups at the moment. And before the trial starts, she's making speeches to the press, bragging about her conviction rates. You can start to tamper with the jurors because the jurors start to think, well, if Fani Willis has got the case, everybody she does is guilty. So then they come to the trial thinking this person must be guilty if Fani Willis is doing it. But what the defendants in this motion, the Trump people and their lawyers, they're called the defendants, but on the motion they brought the motion forward. They said that Fani Willis's speech, she went to a church. And so she goes in a house of God and stands up at the pulpit with a microphone and says, I win my cases. She's essentially almost channeling God through her to an audience of potential jurors to say, I get all the convictions. Righteousness is on my side. And then she does this speech when the Trump and group lawyers are bringing this motion to disqualify. And she starts saying, they're trying to attack the Black man. You know, a white man and a white woman are trying to kick off a Black man. And so she racializes this case in a church, and calls them liars and racists. And that to me is as strong as the conflict. That is forensic misconduct. Like if a prosecutor in another state did that, they would be sanctioned up the wazoo, right? Think of who's watching that. These are all the potential jurors. And so she's making them get angry at race issues. So they're not going to show up to the trial unbiased. She's trying to affect it. She's trying to use this case to make her into a bigger superstar. It is corrupt and dishonest. It's really not good. And the judge doesn't find forensic misconduct, but he speaks out of both sides of his mouth. He goes on page 19 to say, the same cannot so easily be said of the district attorney's prepared speech delivered before the congregation of a local Atlanta church, January 14, 2024. In these public and televised comments, the district attorney complained that a Fulton County commissioner and so many others questioned her decision to hire Wade. When referring to her detractors through her speech, she frequently utilized the plural they. The states argue the speech was not aimed at any of the defendants in this case. That's bullshit. But, she didn't say them by name. And the judge says, maybe so, but maybe not. Therein lies the danger of public comment by prosecuting attorney. The district attorney left the question open for the public to consider. It's him being very weak. You can't say maybe so, maybe not. You should be very clear. This is completely inappropriate. She shouldn't have said anything. It tampers with the jury. More at issue, instead of attributing the criticism to a criminal accused's general aversion to being convicted, the district attorney ascribed the effort to remove them as counsel as motivated by playing the race card. She went on to frequently refer to Wade as the black man, while her other unchallenged special prosecutors were labeled as one white woman and one white man. So she essentially said they're trying to get Wade off the case because he's a black man, but the other prosecutors that were on the case, they didn't try to get off because they were white. No, they were trying to get Wade off the case because he was billing $700,000. Nobody else was billing that much, and you two were screw it. Like, it's got nothing to do with race. And the judge is essentially identifying that by saying the effect of the speech was to cast racial aspersions at an indicted defendant's decision to file a motion they were allowed to do. This is not right. Then he goes again, however, the speech did not specifically mention any defendant by name. And then he says, in addition, this case is too far removed from jury selection to establish a permanent taint on the jury pool. Again, nonsense. Everybody is watching this case in that county. Everybody is going to watch every news story every week until it goes. It's not too far removed, sir. It is critical to getting an unbiased jury. And what he's done is, even if a conviction ever happens, it will be appealed and likely overturned just based on the fact that the prosecutor tainted the jury pool. That is just ridiculous. He could have kicked her off from that, but he's scared of her. Upsets me. Fani Willis, when she goes in front of a church and speaks like this, is essentially talking like a football coach, trying to get supporters to get excited for the game, right? We're going to kick those boys' butts. You know what I mean? Those guys are weak. We have this, we have this. Like, that's what she's trying to do. She's trying to create support for her cause to win. That's not what being a prosecutor is. This ruling by the judge, it may be quoted, it may allow district attorneys to try to influence the game through a microphone in the past. It allows them to be weasels because they can secure the same effect. But if they don't use names, it's not enough. So they can go out there and talk about a case that's national, and in Fulton County it's compelling, but not use names, and so it's not forensic impropriety. He's given prosecutors a license to try to win cases in the media before a defendant has their fair day in trial. Here's an example of two ways you could do it. Let's say you're an honorable district attorney and you're asked to go speak at a church in a similar fact scenario. And they say, hey, can you talk about this very important case to our community? I'd say, my name is Philip Miller. I'm the district attorney prosecuting one of the most challenging cases in our nation's history involving a former president. And what I can promise every one of you that I'm going to do is my best to make sure that justice is discovered, right? And I will do everything I was elected to do to make sure that no stone goes unturned, but that we follow the rule of law. We make sure that the defendants get a fair trial. And at the end of the day, win or lose, I will know I would have given everything I can to protect the citizens of the Fulton County. That's what you can say. But if you're a corrupt weasel who wants to try and use this case to vault yourself into some political future because the Democrats are praising you, you get up there and you do this propaganda speech which says, I get convictions, God is on my side, the people are attacking black people. These people are all racist. It's unheard of to allow a prosecutor to do that. And I don't see how any appellate judge with an ounce of integrity doesn't look at this and say that was completely inappropriate. And you can't prosecute the case. You've tainted the jury pool. You've tainted yourself. You've tainted the district attorney's office. And you did it in a house of God. Shame on you. The judge finally on page 20, after he says establish a permanent taint on the jury trial, as best as the court can divine, interesting word when the speech was in a church, this court cannot find that this speech crossed the line to the point where the defendants have been denied the opportunity for a fundamentally fair trial. That requires the district attorney's disqualification. As you can tell, I completely disagree with this. But the next sentence starts with but, which you generally don't see a paragraph start with but it was still legally improper, period. Right? This is a freaking huge but. Like, if it was legally improper, period, then you're off the case as a prosecutor. How do you quantify the damage when you're sitting in front of a microphone and he announces that it was on radio and TV? How does the judge know how many people heard that? How does he know what the damage is done? The appearance of impropriety is there, and he says it was legally improper. Providing this type of public comment creates dangerous waters for the district attorney to wade further into. So he says, "Oh, maybe we should tell her not to do this again." It's complete cowardice. But where I give him some credit is he puts on the paper it was legally improper, and again, that's a paving stone for the Court of Appeal to drive down and say, "Hey, this impropriety was big enough that we can overturn it." In the end, to sum it up, I hope you guys don't mind me reading some of it. I wanted to touch on some of the points that I thought might be interesting to you. My feeling is that Justice McAfee phoned it in. He didn't want to step up. In our careers, in our lives, we face decisions where we can do the right thing and fall on our sword and feel like we lived a good life. Or we can kind of try to survive and live a life in which we're kind of ashamed of ourselves when we look in the mirror, and our spouse always kind of realizes after that you don't have the same oomph that you used to have. But I understand what he did. He's in a difficult situation. We don't know what we would do if we were in that situation. We don't know what kind of pressures exist in the background. We saw how Terrence Bradley went from wanting to tell the truth, being helpful, to all of a sudden being a complete imbecile who couldn't remember anything. Something was influencing him there. There are things going on behind the scenes that we don't see. We would hope people always do the right thing, but not everybody does. But I think what Justice McAfee did in terms of having some courage is he had the courage to at least put onto paper serious problems that a Court of Appeal can sink its teeth into and overturn the decision and remove her. And by granting that appeal so quickly, this case is going there before the case goes forward. And I predict that she is going to be off the case well before the election and well before the trial. In one hand, it was Cirque du Soleil contortions to try to not come under the crosshairs of Fani Willis, but to allow somebody else to take the kill shot later. It was, a stick handling that lacked strength of character, but essentially didn't completely give it all over. And so in the end, I think he's got a little bit of, it makes sense to me. I would never have wanted him to be in his position. What I would have done if I was him is I would have allowed them to cross-examine the crap out of her when Fani Willis came into the court with that attitude. I would have given him free rein. I would have sanctioned her, and I would have let the defense lawyers make it look so bad that his decision was easy. But I think he kind of protected her as a favor and then said, hey, she survived, so he kind of gave her a small favor, and now she has another life to fight the battle. That's my summary of this case. I look forward to your comments. I look forward to doing more content for you guys. I appreciate your support. I want to do more of this because all of these battles in the real courtroom are exhausting, and I really enjoy interacting with you guys who seem to care about what's important in our society. Until next time, I'm Philip Miller, the Rogue Lawyer. Chat soon.